Good morning.
Let me hold on. We're still waiting. I see now. Okay, got them both. All right, you're up, Mr. Reese.
Thank you very much. May it please the court. Good morning. I'm Andrew Reese, Bond, Schoeneck & King, representing the appellants who were the plaintiffs in the trial court in this matter. I'd like to begin by reserving 5 minutes for any necessary rebuttal. We are before the court on an appeal of a final order that dismissed the plaintiff's derivative claims with prejudice as to two of the defendants that were involved in this case, specifically a company called Sunburst and one of their agents, Ms. Keeter, Beverly Keeter. And this appeal arises from a derivative action filed by the plaintiffs as members of a condominium association. The allegations in the lawsuit involved mismanagement and also breaches of duty by certain board members, as well as the management company and the property manager that had been hired by the association, being Sunburst and Ms. Keeter. There were originally 5 defendants in this lawsuit: the condominium association itself, Somerset, 2 of the board members named the Buffingtons, the property management company, Sunburst, and then the property manager, Ms. Keeter. All of the defendants originally took advantage of the opportunity to move for a dismissal of the derivative claims under a specific statute that applies here, section 617.07401. And that statute permits a dismissal of derivative claims. This is under the nonprofit corporation statute, if certain elements are established. First of all, there has to be a reasonable investigation of the complaint that was made to the board of directors of the corporation. And then second, there has to be a good faith decision made by an independent group of directors that pursuit of this derivative claim would not be in the best interests of the corporation or the association. And if those elements are met, then admittedly, the statute permits dismissal of the derivative claims, early in the process, if it can be established. So in September of 2020.
So to that point, is what you're asking us to do is to reweigh the evidence that the judge looked at?
No, not at all.
Conclusion?
No, not at all. Because in this instance, with respect to Sunburst and Ms. Keeter, the trial court never got to the merits of the evidence, never reviewed the evidence that was before it on this second motion to dismiss. The focus here is not on the first round of motions to dismiss, but rather on the second motion to dismiss that was filed by Sunburst and Ms. Keeter. So no, we're not asking.
Mr. Reese, I was a little, let me be sure I have the scenario straight. The board received a letter outlining or a claim outlining bad behavior. The board, hired someone to look into that.
Correct.
At that time, did that letter mention the management company?
I don't believe that letter specifically mentioned the management company.
Okay, and so then the suit was filed, and the report comes back, hey, nothing to see here, or it wouldn't be in the association's best interest.
Correct.
But then when the suit was filed, the list of the defendants exceeded the list that was named in the letter, correct? And I guess exceeded the people named in the investigation. Would that be correct?
It included Sunburst and Ms. Keeter, who were not specifically mentioned in the complaint letter, correct?
Okay, or mentioned in a report from the investigation?
That I am not 100% sure.
All right.
Yeah.
And is that why? I'm trying to understand why. Once this is all completely a derivative action, correct?
Correct.
And so why under the statute, once the court dismisses the association, can you continue to proceed against these defendants?
Well, the trial court can, and in this case did, reach different conclusions as to whether or not some of these defendants should be dismissed. So the first time around, the trial
Right.
court decided that Somerset, the association, should be dismissed, and the trial court decided that the Buffingtons should be dismissed. And those final orders were limited to those defendants. But the trial court entered a third order, separate order, specifically denying the motion to dismiss as to Sunburst and Ms. Keeter.
So was the dismissal that you have appealed here, was that the judge reconsidering what should have been done? I mean, again, this is a derivative action. I don't know how your client can sue them directly without the association in the case.
Well, because the action is in the right of the, or in the interest of the association.
Okay.
But they don't necessarily have to be part of the
They
case.
don't have to be a party.
Right.
All right.
That's correct. And the trial court's order as to Sunburst and Ms. Keeter the first time around specifically said the motion to dismiss based on their failure to comply with section 617-0401, being the plaintiffs, is denied without prejudice. And so the court specifically dismissed some defendants and decided not to dismiss other defendants. And that was the situation we were left with after the hearing in September 2020. Now, the other defendants, the orders as to them, they were appealed on a related appeal. Those were affirmed, and that's put to rest. But the court gave the plaintiffs the ability to amend the lawsuit as to Sunburst and Ms. Keeter, primarily to correct some technical pleading issues on some of the claims. But the plaintiffs took advantage of that opportunity and filed the amended complaint. And after the filing of that amended complaint, the Sunburst and Ms. Keeter came back and they filed a new motion to dismiss under the same statute related to the amended complaint. The second motion to dismiss contained some new evidence and some new argument for dismissal of the derivative claims. The first time around, their motion to dismiss focused on whether a complaint had been made about Sunburst and Ms. Keeter and et cetera. The second time around, there was also focus on whether there had been an investigation and whether the vote had been proper. In opposition to that second motion to dismiss, the plaintiffs filed their own affidavit, and that affidavit contained evidence contrary to the claims of the defendants. It provided evidence that the investigation was not reasonable, it was not fully complete.
Wasn't that just the affidavit of the plaintiff's own lawyer?
It was the affidavit of the attorney who was involved at that time, yes. Yeah.
And she had, from what I recall, she said, well, I've read the report. And so this is based on my firsthand knowledge, having read the report, which.
But I'm sorry, she was actually involved in the process. She had met with the person who conducted the investigation and was involved in the process herself.
Okay, well, let me, the investigation determined that suit was not in the best interest of the corporation because there were just no damages. So regardless of who might have done what, at the end of the day, there were no damages, and so the suit wasn't in the best interest. Now, if the investigation had turned on the actions of the specific defendants and said, defendant A hasn't done anything wrong, defendant B hasn't done anything wrong, then maybe I would, that might be more persuasive. But the corporation has decided we're not going to pursue this suit because it's just not worth it, regardless of who's involved. And so why wasn't the trial court entitled to look at that and say, this suit is going nowhere. The corporation doesn't want to pursue it against anyone because of the end result. And so how did the court err in doing that?
Well, first of all, on the second motion to dismiss, the court never got that far when it came to considering the amended complaint against Sunburst and Ms. Keeter. And I haven't quite gotten to that point yet, but the trial court never got that far. But even if the trial court had gotten that far, the court needed to weigh the evidence submitted by Ms. Keeter and Sunburst in favor of finding that there was a reasonable investigation and the decision was made in good faith and by an independent group of people, against the evidence submitted by the plaintiffs that showed that the investigation was not complete and was not reasonable, and also that there were questions about the good faith and the independence of the people who took this vote. And that was what was in the affidavit submitted by the plaintiffs. So if the court had gotten that far and weighed that against each other, that's fine. And maybe we would have won, maybe we would have lost. But the trial court never got that far when the second motion to dismiss came around. Because what the trial court did on that second motion to dismiss, rather than reaching the merits of that motion, the trial court said, I've already dismissed the case, the derivative action as to the association, and I find that that includes the management company. In other words, Sunburst. And that is directly contrary to what the trial court had done the first time around. The trial court specifically did not find that the dismissal of the association included the dismissal of Sunburst and Ms. Keeter. In fact, the court entered 3 separate orders.
Right, but that's why I asked, could this, well, and I, this is going back and looking at your brief again, the seemed to me that the court was kind of going back through that whole scenario in its mind, and although it didn't say I'm reconsidering that order, it kind of did what, maybe I think it's a she thought should have been done at that time.
We don't know, because there isn't anything in the record that indicates that this was reconsidering what she had done before. And
well, she says, I'm going to find that I've already dismissed the derivative action, and that includes the management company, even though, in fact, back at the time, that's not what she had done. That's why I'm wondering. Okay.
But that's one interpretation of what she's saying. But I think what Judge Northcutt's saying, that first sentence is a repeat of historical nature. I've already dismissed it against the derivative action, and it included previously the management company. The second part is more of a prospective statement. It includes the management company as well. That would be a reasonable interpretation of that statement, even though yours may be as well. We'd have to get into the mind of the judge to know. A written order doesn't come out and say, I previously dismissed all of these, why is it here? Or, I changed my mind. It just says they're dismissed.
And there's no indication that she in fact had changed her mind, or what. I can only go by what she said at the hearing. And what she said at the hearing was that my prior ruling included the management company. And that's not.
Where is that in the record?
That's what she said. She said,
well, that's just it. That's your interpretation. She said, I'm going to find that I've already dismissed the derivative action. She didn't say, I'm going to find that I've already dismissed the management company as part of my previous dismissal of the derivative action, which is what your interpretation is.
But when she says, I'm going to find that I've already dismissed the derivative action, she had only dismissed part of the derivative action. She had not dismissed the derivative action, at least not with prejudice, as to Sunburst and Ms. Keeter, and that survived. And so the plaintiffs were entitled to have her review the merits of the second motion to dismiss, rather than to have her recast history and say, even though my orders did not say this, I'm going to find that this is what they said. And our point is that when it came back around, the plaintiffs were entitled to have the merits of the second motion to dismiss weighed. So, I mean, this is a fairly unique statute in that it allows the dismissal of these claims pretty much out of the gate even before really discovery has a chance to get started. And the burden is on the moving party to prove the elements necessary for a dismissal. And we would submit that the plaintiffs are entitled to have them put to their burden and have the court weigh the merits of the motion that they filed. And again, that's setting aside the issue, which is also in our brief, as to whether the Sunburst and Ms. Keeter had standing to bring this motion, because the statute specifically says the motion can only be brought by the corporation.
No, not the motion to dismiss. That's not, the statute says the court may dismiss a derivative proceeding if on motion by the corporation, the court finds that one of the groups, and it goes through the criteria, but it doesn't say the motion to dismiss has to be brought by the corporation.
Well, it says in subsection 3, the court may dismiss a derivative proceeding if on motion by the corporation. So that,
right,
that
and on motion by the corporation, the court had already found that one of the groups specified in paragraphs A through C has made a good faith determination, et cetera, et cetera. The corporation has to request the court to make the requisite findings, but
Correct.
That's not the same thing as saying that the corporation has to move to dismiss on behalf of all the defendants, which is what you're suggesting.
Well, the first time around, and I suppose the corporation, the association, could have moved for dismissal of all of the defendants, which it chose not to do, and left the management company and Ms. Keeter to move on their own. But if that sentence doesn't mean that only the corporation can make the motion, then I'm not sure what the language means.
Well, you keep saying the motion, and I'm talking about specifically a motion to dismiss. The corporation had already moved for the court to make the requisite findings under the statute, but that's
only
not
only as to the association, though. The corporation had not moved as to Sunburst and Ms. Keeter. They moved separately on their own. And our point is that the statute seems to say, and it needs to be strictly construed, that the motion must be made by the corporation. Now, for whatever reason, the association chose only to move as to itself the first time around. That's their decision, that's fine. But under the statute, that seems to indicate that the Sunburst and Ms. Keeter cannot make that motion on their own. And I'm sorry, where am I with my time here?
I'd like to go into your rebuttal time.
Okay, well, I think I've covered everything I need to cover, so that's fine.
Okay, good. All right, let me see what we are here. All right, Ms. Munoz.
Good morning, Your Honors. May it please the court. Adriana Dela Cruz on behalf of the appellees, Beverly Keeter and Sunburst Management Corporation. The final order dismissing Ms. Keeter and Sunburst should be affirmed where the record demonstrates that the association, Somerset, conducted a reasonable investigation of the allegations of wrongdoing, and that by majority vote, a group of independent, disinterested directors made a good faith determination that pursuing the action is not in the best interest of the association. Now, it is important to note, as my colleague mentioned, that a panel of this court previously affirmed dismissal of the association and two former directors, the Buffingtons, in a related appeal, case number 2D20-3268. Now, in the trial court, the association and the Buffingtons submitted the affidavit of one of the independent, disinterested directors, Peter Polibiaco, along with the entire report of the attorney hired to conduct the investigation, Robert Morrell. In dismissing the Buffingtons and the association, the trial court, relying on the evidence before it, namely the affidavit and the investigation report, found that the lengthy investigation was reasonable and that the board had acted in good faith. Following the appellee's motion to dismiss the amended suit, the association, on behalf of Ms. Keeter and Sunburst, submitted a second identical affidavit of Peter Polibiaco, reaffirming and attaching his initial affidavit along with the investigation report. Within the second affidavit, Peter Polibiaco explains that the board conducted a meeting specifically to address the allegations of wrongdoing against Ms. Keeter and Sunburst. At the meeting, the board reviewed the investigation report and found that pursuing the action is not in the best interest of the association. Now, the reason that the board was able to come to that conclusion is because the investigation conducted by Robert Morrell covered all allegations of wrongdoing against all defendants, including Ms. Keeter and Sunburst. And appellants acknowledge as much at the September 25th, 2020 hearing on all appellees' motions to dismiss on page 475, lines 9 through 12 of the record. Now, Mr. Morrell's report painstakingly details his investigation of and recommendations as to each of the allegations of wrongdoing. Additionally, the report demonstrated that the vote was undertaken where a quorum of directors not subject to the allegations voted not to pursue the action. The report also provides the factual basis for the recommendations. As it relates to the use of the reserve funds, the report finds that the association members suffered no actual damages. As to the remaining allegations of wrongdoing, the report finds that the decision was within the discretion of the board of directors under the business judgment rule. And it is important to note that pursuant to Share versus Broken Sound Club, a court presumes that corporate directors have acted in good faith. Now, in dismissing Ms. Keeter and Sunburst, the trial court relied on the same evidence as when it dismissed the association. The trial court properly found that based on the evidence before it, namely the affidavits and the investigation report, Ms. Keeter and Sunburst satisfied the standard for a motion to dismiss under the statute. Respectfully, this court should affirm dismissal of Ms. Keeter and Sunburst for the same reasons it affirmed dismissal of the association. Now, moving on to my second point, the appellants argue that the trial court erred in dismissing Ms. Keeter and Sunburst based on its prior decision to dismiss Somerset, where the order dismissing Somerset had no language pertaining to Ms. Keeter and Sunburst, and where the trial court initially denied, in part, the appellee's motion to dismiss the original complaint. The appellants, however, failed to cite to a single case or other authority to support its proposition that the trial court erred. Additionally, the fact that the trial court initially denied, in part, the appellee's motion to dismiss is irrelevant. Following the order denying the motion to dismiss, the appellants filed an amended shareholder derivative suit. Thereafter, the appellees moved to dismiss, and the court granted dismissal. Pursuant to Egan versus Federal Deposit Insurance Corporation, the amended shareholder derivative suit supersedes the original complaint, and thus the order denying the motion to dismiss the original complaint is likewise superseded. The trial court did not err in dismissing Ms. Keeter and Sunburst based on its prior decision to dismiss Somerset. Now, moving on to my next point, the appellants argue that Ms. Keeter and Sunburst did not have standing to bring a motion to dismiss under the statute. Irrespective of this argument, the trial court properly found that because the shareholder derivative suit was dismissed with prejudice as to Somerset, the amended shareholder derivative suit must necessarily be dismissed with prejudice as to Ms. Keeter and Sunburst. The appellant should not be permitted to use the statute as both a sword and a shield. Moving on to my final point, the appellants argue that the trial court failed to consider the affidavit of one of its attorneys, Jessica Palombi. However, the issue of whether the trial court failed to consider the Palombi affidavit was not preserved for appeal. Pursuant to Sunset Harbor Condominiums versus Robbins, it is inappropriate to raise an issue for the first time on appeal. And here, the appellants failed to move for rehearing upon entry of final judgment. Additionally, at the March 2nd, 2021 hearing on the appellee's motion to dismiss the amended suit, counsel for Ms. Keeter and Sunburst raised the affidavit, explaining that it was nothing more than arguments and opinions of counsel. The appellants also discussed the affidavit at this hearing, as can be seen on pages 547 through 550 of the record. There is no record evidence to suggest that the trial court failed to consider the Palombi affidavit when it dismissed the amended shareholder derivative suit with prejudice. Respectfully, based on the evidence before this court, namely the affidavits and the investigation report, this court should affirm dismissal of Ms. Keeter and Sunburst for the same reasons it affirmed dismissal of the association. And unless this court has any questions, the appellees rest on the arguments made in the brief. Thank you.
Reese? I was reading stuff on your case while you were arguing the case, and I'd let you get into your rebuttal without a warning. So I'll give you like an extra minute. So you're at 4 minutes. How's that?
No, that's okay. I won't need that much.
Okay.
I would just like to point out that the separate orders that the court entered the first time around indicate that the trial court found that the standard under the statute had been met as to 3 of the defendants, and the standard had not been met as to the 2 remaining defendants. And so the second time around, on the second motion to dismiss, what was the court's basis for concluding that it somehow did meet the standard the first time around without considering the merits of the second motion to dismiss?
Let me tell you, I have a concern about Mr. Reese in light of the statute. The statute really says, and as you pointed out, the corporation doesn't have to be a defendant, but even if the corporation is not a defendant, as I would read the statute, the paragraph, the court may dismiss a derivative proceeding if on motion by the corporation. And that's what happened. I'm not sure that the statute allows the court to dismiss parties versus the proceeding. And I mean, I recognize that it's kind of a new issue I've raised here, but I have a concern about the first time around. Could the court just say pick and choose defendants versus the proceeding?
I understand the language of the statute. Notwithstanding the language of the statute, I think the court certainly could find that the standard had been met with respect to some of the defendants and not others. I think that is possible, and that may run contrary to the strict language of the statute, but that is what the trial court chose to do here. And my concern is that the second time around, the court somehow found that the standard had been met as to Sunburst and Ms. Keeter the first time around, even though the first time around the court specifically found that it had not been met. And it did so without looking at the merits of the evidence for and against the claim, the dismissal of the claims against Sunburst and Ms. Keeter. And we are simply asking that the trial court be required, before dismissing these derivative claims once and for all, that the court be required to consider the specific merits of the evidence that was submitted both by Ms. Keeter and Sunburst as well as by the plaintiffs, so that we are sure that the standard required by the statute has been met. And unless the court has any additional questions, I've concluded my argument as well.
Thank you. Thank you both very much.
Thank you.
In order to leave our virtual courtroom